On November 3, 2016, the Utah Court of Appeals issued its decision in the case of In Re M.W. Here's the link to the complete decision, which is also included in the description section below for this report. In the spring of 2014, in the presence of one or more of his peers, the child A.B. accused the child M.W. of having raped him in the summer of 2013. The state filed a petition accusing M.W. of sodomy on a child. The juvenile court held a bench trial at which 5 witnesses testified. A.B. gave his personal account of the rape and identified M.W. as the perpetrator. A.B.'s father testified that M.W. came to their front door and told him about A.B.'s allegation. Both A.B.'s father and A.B.'s mother related additional information about the confrontation at the front door, including A.B.'s statement that M.W., quote, raped me, close quote. A detective who investigated the incident testified that M.W. told her multiple times that A.B. had accused him of rape. M.W. does not appeal the admission of any of this testimony. Additionally, a doctor who examined A.B. testified over M.W.'s counsel's hearsay objections that A.B. told him that M.W. had raped him. The juvenile court found beyond a reasonable doubt that M.W. had committed sodomy on a child and entered a disposition order. M.W. appealed, arguing that the juvenile court erred by admitting and relying on the doctor's statement that A.B. told her that M.W. had raped him, and that without the doctor's testimony there was insufficient evidence to find him delinquent. The Court of Appeals concluded that M.W. offered essentially the same evidence himself. While claiming it was error for the juvenile court to allow the doctor to describe the person A.B. identified as the perpetrator, M.W. offered the recorded statement of a detective, which indicated that a doctor had told her that A.B. identified M.W. as the perpetrator. In other words, M.W. advanced the argument that doctor cannot testify as to the hearsay statement of A.B., yet in a different hearsay statement, in a recording no less, of the detective can relate the hearsay statement of a doctor describing the same hearsay statement of A.B. The end result remains. M.W. put into evidence the same statement he now claims the juvenile court erroneously admitted elsewhere in the record. Second, every other witness related the exact same information, that A.B. identified M.W. as the perpetrator, and M.W. himself provided the same information through other evidence. Therefore, the testimony of the doctor was merely cumulative, and any error in its admission was harmless. The Court of Appeals' determination that the doctor's testimony was harmless also resolves the question of whether sufficient evidence existed outside the doctor's testimony to support M.W.'s adjudication. The testimony of the doctor disclosing that A.B. identified M.W. as the perpetrator was hardly the keystone of the state's case. And because identical evidence from other witnesses identified M.W. as A.B.'s assailant, there was sufficient evidence to adjudicate M.W. delinquent even if the doctor's testimony were ignored.